Welcome to the No Unfinished Business podcast. There are 1,000 different ways your clients can leave unfinished business, but no single advisor can address every issue. In every episode, we'll answer the important questions to help professional advisors focused on individual clients. Attorneys, CPAs, and financial advisors identify and eliminate those planning blind spots so you can speak competently and confidently to your clients and help them leave no unfinished business.
Thank you so much for having me, John. It's a pleasure.
Yeah. We're bringing you in because something that comes up a lot with clients, both my clients for estate planning, your clients as a family lawyer dealing with, among other things, divorce. Do we need a prenup? And if so, what does this look like?
Well, I think if a party has any assets whatsoever, they really should strongly consider having a premarital agreement. You don't have to state in the agreement that there's absolutely no community property. A lot of clients come in and they do want to share some assets with their spouse. And there are a lot of ways to do that. Of course, the simplest way to draft a premarital agreement is to say there's no community, but there are several other options.
Right. The way I normally hear it from my clients is, well, they've been married for a while. You mean we have stuff that may not be community, that it didn't all just magically turn into community property when we got married? The answer is, well, no, you can only start creating that community set of assets once you are married.
Right. But here's one of the benefits of a premarital agreement. And oftentimes a premarital agreement will restate what Texas law is anyway, but it can contain some language which will eliminate the need for expensive tracing and expensive litigation on divorce. So, for example, it's under Texas law, the court presumes that all the assets on hand are community unless you can prove by clear and convincing evidence that they are your separate property. Here comes the problem. Banks only maintain records for a certain number of years. So if you've got even a marriage 10 years, which isn't, it's somewhat long in family law world, but not an overly long marriage, it can be extremely difficult to go back and get your 401k statements from 10 years ago. So if you have a premarital agreement, and this is another very important aspect, if you're going to do a premarital agreement, give your lawyer ideally give your lawyer your tax return and your actual investment account statements and your bank account statements so that you can prove which accounts existed at the time of marriage. So even if your premarital agreement is just going to restate what is your separate property and restate what Texas law is anyway, it still can be very beneficial because often with longer term marriages, it's very difficult to prove what existed prior to the marriage. And then other types of separate property, of course, are gifts and inheritance. And a premarital agreement can clarify those issues too.
Right. One of the things I've seen come up as well is the couple that's here in Texas for now, but knows they're going to move somewhere else later. And our default rules on community property and separate property, if whatever you bring into the marriage by default is your separate property, but not the income, could be upset if you, say, move to California, where the moment you get there, that income from separate property is now not community property, it's separate property. And that may be what everybody was looking for and understood, but clarifying that in the agreement, if we go somewhere else, we want to keep this agreement in place.
Yes, you can. Choice of law provisions are enforceable so long as the state whose law is chosen in the agreement has a rational relationship to the parties and their property. So if Texas was their state of marital residence, the way Texas looks at, or let's do it the opposite, because I've had a couple clients that are relatively wealthy move here from California. Mm-hmm. And if their premarital agreement says that California is going to be their choice of law, then Texas courts will respect their premarital agreement. And as long as California had a relationship, and as long as the provisions in the California prenup aren't in violation of public policy here in Texas. When I did have the California clients, what we do is I often will have them ratify their California premarital agreement. And if they've changed, like one of the clients that came to me, he had reincorporated his business and his assets had changed drastically since the original premarital agreement. And so, even though other premarital agreement was very well drafted by an excellent California firm, what we did there was I worked with his California lawyer and drafted a ratification agreement for Texas, but worked with her so that we were able to make sure that if they returned to California, we wouldn't mess anything up in Texas. But if they got divorced in Texas, that their California prenup would still be upheld the way they intended.
Right. We've seen that before with other clients who have either moved here, or I've had another client where their child was living in Oregon and we were told you could either have a prenup that covers everything, or you can fight tooth and nail over literally everything when the divorce happens, because everything is on the table. And what was shocking to me as a Texas estate planner, even an interest in a trust created by the other spouse's family that specifically did not name the spouse, that the other divorcing spouse, the non-relation spouse, that non-related spouse still got to use the cabin in the woods that was held in the family trust, because as a result of using the trust over the years during the marriage and without any sort of premarital agreement, that was on the table.
Yeah, and that's an important point. Income in a trust is a very tricky legal issue in Texas in terms of its character. And one great thing you can do with a premarital agreement is provide that income from separate property remain separate property. Because in Texas, there was a case, a really interesting case, a doctor and had a premarital agreement drafted, and it provided that his medical practice was his separate property, but it did not specifically say that the salary he drew from his medical practice would remain his separate property. And so the court found that his salary, also his premarital agreement didn't state that there would be no community property created by virtue of the premarital agreement. So without those two provisions, you have to specifically say that your salary would not be separate property. And so in any event, the reason you might need a premarital agreement, even though your business was created prior to the marriage and it is your separate property, is your income from the business may not be considered separate property. And then in Texas, we also have a claim if someone fails to draw an adequate salary from their business, that can create what's called a Jensen reimbursement claim. And you can avoid a lot of those problems with a well-drafted premarital agreement.
Yeah. Are there any times when you think, I know we said if you've got stuff going into a marriage, at least consider it. Are there any times where you say, well, look, there's just not enough to fight over here, or it's not worth the time and expense of a premarital agreement?
That would be a pretty rare circumstance. And again, most of my clients that come to me do have a retirement account with their employer, or they own a business. Most people, unless they are college sweethearts getting married upon graduation, most people have some assets that it would be beneficial to protect. And even if you have a premarital agreement, you can carve certain assets out. And that's what I really recommend for people that want to clarify what their separate property is, but they don't want to make their future spouse feel like they're not creating future together. So you can create a premarital agreement that the only community asset will be, the homestead of the parties. Also, ways that the moneyed spouse can help the lesser moneyed spouse kind of soften the blow of the prenup is they can provide a monthly allowance during the marriage, or they can have different payments that occur at different points of the marriage. Like after 3 years, the moneyed spouse will pay $100,000, for example, to the lesser moneyed spouse. Or you can have sometimes an exit bonus where if you're married 5 years, they'll be paid 500,000. If they're married 10 years, they'll get $1 million. So there are a lot of ways to have a premarital agreement that can provide a lot of clarity and comfort for the spouse, for the moneyed spouse, but also not leave the non-moneyed spouse out in the cold.
Right. Even if it's just saying normal community property rules apply, except for this thing that the family would prefer you not be involved in if we are no longer married.
But you can do that. But I believe a less complicated way is to say, we're not going to have any community property except for these certain assets, like a family home, or it's much easier because sometimes you can invite tracing problems by very creative lawyers if
Okay.
and claims that again, I have found in my family law practice, I've been practicing family law 19 years of my 30 years as a lawyer and been board certified since 2009. I have found the premarital agreements, while widely upheld and enforced by the courts, they are presumed to be enforceable, but there are certainly some arguments where people can try to get out of them. If there's enough money involved, the lesser moneyed spouse often starts off fighting the premarital agreement to try to squeeze a little more money out in settlement. So it is a lot easier. The cleaner the premarital agreement is drafted and the more simple it is, the better. Again, the way now I'm a divorce lawyer. So I come from the perspective of when things don't work out, it's easier to if you're not going to have no community estate, it is much easier to pick a few assets that the parties will own together or provide for certain monetary cash payments where it's very clear, and then include a no contest clause where if the other side is supposed to receive $5 million upon divorce, if they contest the validity of the premarital agreement, they end up waiving that $5 million payment. And there are some cases out there like that where a spouse made the mistake of trying to contest the prenup and she lost her $5 million. So,
Yeah, it's just figuring out and crafting that agreement for everybody because it's not as though we just drop names in and then we're done.
no, it's very customized. Um,
My practice has always been, look, the and it's always getting to what you're talking about of here, these are the assets we're talking about, attaching copious schedules and sometimes even the statements of this is what's in there as of this date. Especially, is that what you as a divorce attorney would look for as well, just to make sure it stands up later on?
I think that is based on relatively recent case law. I think that is the better practice. And in fact, I would recommend, especially like you spoke about a minute ago, where a client really just wants to protect their family business interest and clarify what they own going into the marriage, but they do intend to create a community. You really do then have to keep every retirement account statement moving forward because the forensic accountants are going to have to trace those particular investments because a lot of people don't understand that income and dividends, interest and dividends paid on separate property stock is income and it's community. And so your account, even if you don't put another penny in that retirement account after you're married, that account becomes commingled. And oftentimes in family law, we do the subtraction method. So say a retirement account upon divorce has $500,000 in it and it had 100,000 on the date of marriage. We used to kind of have the practice of, yeah, you could trace, but we'll just say the community portion is 400 and the separate property is 100. We'll just do some simple subtraction, which English majors like me really, that's attractive. But the problem is it's not really legally correct. And again, the burden is on the person proving their separate property to provide clear and convincing evidence. And there have been some recent cases that provide that the clear and convincing evidence needs to be a trace. And if it's a 17-year marriage and you don't have 17 years of those investment account statements,
Oh my God.
you're going to have a big problem that's establishing your separate property.
Right. Oh my gosh. So, I mean, there's one opportunity. Anything else that, as the advisors who are listening to this, things they should be thinking about putting in place for their clients who may be considering premarital agreements to make sure that not only is it clear now, but if it's ever needed, it will work later.
I would say the biggest help that I would love from my clients' financial advisors is that the financial advisors would help the clients gather their statements. And because a lot of times the trusted financial advisor knows all of their clients' investments. And if they could help their client put together a package for the estate planning lawyer or the family lawyer that's drafting the agreement so that the clients provide adequate detail on the client's assets. Because one of the bases to get out of a premarital agreement is you have to show it wasn't entered into voluntarily. There's no strict definition of voluntary in the family code. And so there's a lot of room for interpretation there. And the person did not receive adequate fair and reasonable disclosure of the assets. And so I have a lot of clients that come to me wanting a premarital agreement and they're reluctant. And I don't know that they're reluctant. I think they just don't want to go to the trouble of gathering detailed information and getting me all their statements on their assets. And it's extremely important. So I would say CPAs, financial advisors, it would be really wonderful if you'd help your clients gather information on all of their statements, meaning on all of their accounts, meaning their statements. And then also, I think it's important for the advisors and the lawyers to tell their clients, you still, even though we have this prenup, if you've provided that there will be community property, you need to keep all your statements going forward and keep them in a secure place so your spouse on the eve of divorce doesn't throw away your statements that you've been saving, squirreling away in the attic.
Not that that's ever happened.
um, yeah. So, and then the other advice I would give to financial advisors and accountants is be sure that the lawyer that you refer your clients to has experience working with clients at the income level that the client is and has experience drafting premarital agreements. A lot of times I think professionals don't understand how extremely specialized different areas of the law are and how important it is to keep up with the changes in the case law.
Excellent. Well, Kathryn, I think that's probably a great place for us to stop for now. If somebody's looking for a little bit more help from you on a premarital agreement, how can they find you?
My phone number is 469-888-8829. And my website is collincountyfamilylaw.com. I practice in Frisco, which is north of Dallas, and I handle Dallas County, Collin County, and Denton County.
Excellent. Kathryn, thanks so much for dropping by.
Well, thank you so much for having me, John. It was a pleasure.
Thanks so much for listening. You can find more episodes, videos, and links to more helpful content at nounfinishedbusiness.com. If you have any questions, feedback, or ideas for topics, please reach out via social media or email John at john@stromeyerlaw.com. And of course, if you or your clients need help from John with an estate planning, probate, trust, or cross-border tax issue, you can book time directly with John at askjohnaquestion.com.